Hello, welcome. I'm Heather Burton with Employer Lawyer. Thanks for attending our webinar today. It's good to have you with us. Our topic today is, can you say that at work? Free speech in the Utah workplace. This is a hot topic. It usually is, but it seems more so lately. So we'll dive in. And if you have questions, please use the Q&A, not the chat, but the Q&A. And we'll get to some questions at the end. First, I just want to say before we dive in that the information we're covering today is for general educational purposes only. It's not legal advice. And so by attending this session, it doesn't create an attorney-client relationship. Employment laws can vary from state to state and change over time. So please be sure to consult your own legal counsel for guidance on your specific situation. So that's our disclaimer. And then again, remember, if you have questions, use the Q&A feature. Okay. So we'll get started. Just a moment. Okay, whoops. Sorry, there's the disclaimer. All right, what is employee speech? So a lot of you will already know that it goes beyond just things that we're saying with our mouths. So verbal expression, such as spoken comments, opinions, jokes, religious discussions, political discussions, all fall under verbal expression. Employee speech can be written or printed expression. So these would be things like emails, text messages, flyers, posters, bulletin board postings, handouts, and buttons or pins that people wear with writing on them. Symbolic or expressive conduct, this would include things like logos or pins with symbols. Grooming styles can also convey messages. Gestures such as kneeling or saluting or flipping someone off, and even silence can be expressive conduct. Then we have digital and social media posts, and we all know this is a huge category these days, so that doesn't require any explanation. And even nonverbal acts. So this overlaps a lot with the symbolic or expressive conduct category, and it can also include participating or refusing to participate in certain events or pledges, things like maybe a DEI training. Sometimes this comes up for people, or the Pledge of Allegiance. Those are a couple examples. I'm sure there are more. These are all considered speech, and in this realm, we're talking about employee speech. So employers can generally regulate speech inside the workplace to protect the business's legitimate interests. So some examples of legitimate business interests would be, of course, productivity, efficiency, safety, security, harmony. It's sometimes referred to as cohesion, similar idea, discipline in the workplace, and morale. And then, of course, legal compliance, such as non-harassment and non-retaliation policies. And I'll add here, these aren't on the slide, but I'll add things like protecting confidential information and trade secrets, or meeting revenue goals or other business goals, and maintaining good relationships with customers and clients and vendors, etc. So just a moment. I think I got ahead of myself on this slide. There we go. Sorry. Thanks. I'm working with multiple screens here. So employers can generally regulate employee speech outside of the workplace if the speech interferes again with legitimate business interests. And when I say regulate in this context, I mean they can mete out employee discipline as needed to protect the business's interests. So examples of these, whoops, I keep doing that with my cursor, would be, sorry, these look a little different than, give me just a moment to get my slides together, sorry. Okay, I think we one of our slides is a little different. So I'm just going to talk you through this one. So outside the workplace. So this would be engaging in unlawful discrimination or harassment or retaliation against coworkers outside the workplace. And this can occur in person or in online forums. And also, it can happen by interfering with the employer's core mission. So some examples of interfering with core mission. I'm just going to throw out a few. I'm sure you can imagine a lot of others, but just to get our minds kind of thinking about core mission, a police officer posts racist or violent content that undermines public trust, that would be interfering with core mission. Or a prosecutor publicly advocates for ignoring constitutional rights, that would interfere with core mission. An employee working for a domestic violence shelter defending abusers online, again, core mission. Or an employee of a green energy company maybe mocks climate change, that would be interfering with core mission. Some other examples would be interfering with the employer's public image. So this would be an example would be an employee's LinkedIn profile if it prominently displays the employer while posting inflammatory opinions. That would be an example of a public image problem. Or let's say an employee of a health and wellness branded company sharing pseudoscientific statements online, that could be a public image issue. Also operations, so an employee's off-duty conduct, if it's so upsetting to coworkers that it results in investigations, complaints, high turnover, this could be interference with operations. Another example is if employee speech outside the workplace interferes with client and customer relationships, and this definitely does happen. So an example is a customer is offended by an employee's online post and they call the company to complain or threatens to pull their account or something. This would be definitely a threat to the employee or the business's interests. One other example is confidential information. So let's say an HR worker publicly discusses pending layoffs. That would hurt the employer's confidential information. Or let's say an employee shares images of proprietary equipment or pictures of a restricted area within the company. Again, a threat to confidential information. So let me see if I can get the slides working for me again. Okay, yes, we're back on track. So some laws specifically limit an employer's ability to regulate speech. So we've been talking about ways in which the employer can regulate speech for its employees. Now we're going to talk about some of the limitations on that ability. We're just going to cover two today. There are a couple others that I'll mention at the end, but it's just more than we would want to tackle during one webinar. So we'll touch base with, we'll touch on the NLRA, the National Labor Relations Act, which applies to most private employers. And then we'll talk about the Utah Anti-Discrimination Act. So for an employer to be covered by the NLRA, Section 7 specifically of the NLRA, they need to be a private sector employee engaged in interstate commerce, and they have to have a certain amount of gross revenue. And then the analysis gets a little more complicated after that, so I won't get into it other than to say, if you're not sure if you're a covered employer under the NLRA, then definitely reach out to an employment lawyer and figure that out, because it's an important thing to know. So employee speech that is protected by Section 7 of the NLRA is speech that constitutes concerted activity for the mutual aid or protection of employees. And examples of NLRA protected speech, this would be things like discussing wages, hours, or working conditions, including discussions online or via text. This would include complaining to coworkers or management about unfair treatment or workplace policies. This would include distributing literature or wearing insignia, buttons, shirts related to labor or working conditions, and communicating with government agencies such as OSHA or the Department of Labor. But, so we had regulation of speech, and then we had limits on the employer regulation of speech, and now we're going to talk about the limits to what is protected under the NLRA. So examples of employee speech that is not protected by the NLRA that the employer can still regulate. These would be things like individual gripes, individual is the key word, with no connections to group activity, because the statute protects concerted activity, not just a lone wolf activity. Also, disloyal statements that are not related to working conditions. So like disparaging employees' product or service, not protected by the NLRA. Also, speech that is recklessly or maliciously false about the employer, then you're into, the defamation realm. Speech that is disloyal in a way that is unrelated to workplace conditions, so just bashing on the company or its executives in other areas, not protected. Speech that violates anti-discrimination and harassment policies, and speech that disrupts work, the actual work of the company, endangers safety, or discloses confidential business information. So you can't go running through the warehouse, shouting, disrupting work with your grievance. That's not protected. Just give me a moment. Okay. Now, we touched on the NLRA. Now we're going to move to the Utah-specific Utah Anti-Discrimination Act, sometimes referred to as UADA. So this generally applies to Utah employers with 15 or more employees. And we're going to be talking about, so the Utah Anti-Discrimination Act, it's a pretty extensive law. We're going to be talking about specifically one section of it, which I didn't put it on the slide, but it's section, for those who care, section 34A-5-112 of the Utah Code. So there's little legalese for you. This says, and there are quotes here, this is straight from the statute, that inside the workplace, expressions of religious or moral beliefs and commitments made in a reasonable, non-disruptive, and non-harassing way must be allowed on equal terms with similar types of expression allowed by the employer in the workplace. So they're trying to set up this balance here. The trick for an employer is to be somewhat content neutral. Obviously, you don't want to allow content that creates problems for the legitimate business interests, but just somewhat, you want to shut down certain people saying, I have this moral belief or commitment or religious belief, and other people with moral beliefs religious or moral beliefs and commitments, it's a mouthful, you shut down their content. So you're just trying to be as content neutral as you can, but also making sure that you get to maintain your workplace in a way that the communication is reasonable, non-disruptive, and non-harassing. So there's some real balancing happening here with employers. And I'm sorry, that's the life of an employer. Just be aware. See, this is in the anti-discrimination statute. It makes sense that what it's addressing is these equal terms with similar types of expression. So you're looking for a balance. I'll mention too, this particular section of the law was passed in 2015, and it was just amended in 2024. So it's a very active area of the law in Utah. Chances are it will change again. So far, there aren't any court cases citing this law. So I can't tell you, that this law has been tested and this was the result, but here it is, it's on the books. So we got to pay attention to it. Now we'll move to outside the workplace. So outside the workplace, employee speech that's protected is lawful expression or expressive activity. Watch the quotes again, regarding the person's religious, political, or personal convictions. So notice here they're bringing in, it's not just about religious and moral things, they're also bringing in political, personal convictions. So it's addressing a broader scope of speech. And then it specifically says, including convictions about marriage, family, or sexuality. So you can see a little bit of the hot topics that people are paying attention to these days being addressed by this statute. Okay. Now we're going to talk about employee speech that is not, again, protected by the Utah Anti-Discrimination Act. And this is going to look familiar. So speech that is unlawfully discriminatory, harassing, or retaliatory, not protected, obviously, by the Anti-Discrimination Act. And any speech inside or outside the workplace, and this is in the statute, quotes again, that is in direct conflict with the essential business-related interests of the employer. So as they enacted this law, they were conscious of these limitations that have traditionally been in place, that employers do get to protect their business interests. So again, we'll mention speech that interferes with the employer's core mission, public image, operations, client-customer relationships, confidential information. Employers don't have to tolerate these things being attacked as they're performing this balancing act of allowing speech inside and outside the workplace within those guardrails that the statute sets up. So I'm just going to mention, this is bonus material. If you want to come to a future webinar, we're going to cover some other things. So under the Act, this same section of the Act says that employers may not compel certain types of religiously objectionable expression, objectionable to the person being compelled. So it's a different angle on the law. Instead of what the employer must allow, it's a limitation on what the employer can do in terms of compelling speech. So I'll just read to you. This isn't on the slide. I apologize. It was a last minute decision to read this to you, just to pique your interest. So a quote from the statute says that religiously objectionable expression may include expressive action or inaction that burdens or offends a sincerely held religious belief, including dress and grooming requirements, speech, scheduling, prayer, and abstention, including abstentions relating to healthcare. That's a lot. That's a lot of ground right there. So future webinar. And then also some types of whistleblowing, of course, because it's by definition, whistleblowing is somewhat protected. So we can do a different webinar on employee protected speech in the context of whistleblowing. And that is all of the main content I had to present for you today. If there are questions, I will ask our administrator. She can bring them up. And if not, then thanks for your very valuable time today.
Okay, any questions? Right now, I don't have any in the Q&A. We'll just give it a minute, see if people are typing.
Yeah, that's totally fine.
We had a good turnout though, so thanks everyone for attending.
Yes, thank you. It's good to have you with us.
Okay, if there's no questions that pop in the next 10 seconds or so, if you have questions, you're always welcome to reach out to our team. Our phone number and email is on there, and we're happy to talk to you guys further about this. Okay, I think we're good to wrap up then. Thank you guys for taking time out of your Friday.
Thank you, everyone. Take care.